Collaboration with other influencers is a great way to gain attention and growth in your audience platform. But every influencer should be prepared to use a release and consent agreement in his or her online endeavors. In this video, I'm bringing you 6 essential contract clauses to protect you while you build your audience. And your legal lesson starts now. Hey, how's it going? I'm Andy Contaguglia, a lawyer based here in Denver, Colorado. I am bringing you your legal lessons in business. It is my goal to educate you about the law in business. As I previously mentioned, collaboration with other influencers is a great way to gain attention and growth to your audience platform. However, every influencer should be prepared to use a release and consent agreement in his or her online endeavors. Failure to do so can lead to significant trouble down the line. Now, typically these agreements are used to obtain consent from other people who are appearing in your videos or in your podcasts for you to film and record them. If you are planning on commercializing their contributions, a collaboration agreement can help the parties understand the nature of their relationship and what is expected from each one another. In many instances, online influencers rely on free release forms that they can get online to obtain these results. However, one must be wary about such online forms because you have to be careful that the form actually provides sufficient protection, especially when you're partnering up with somebody on your show. If you haven't already watched, take a look at this video here about why I believe form contracts are not the best, and that you should actually take the time to get to know the person that you're involved with and reach an agreement that's beneficial to everybody. So in an effort to safeguard the protections for you, the influencer, you should include the following 6 clauses in any agreement that you plan on entering into with a collaborator for your collaboration. All right, so the 6 contract clauses that you need to be prepared to use in your collaboration agreements are as follows. Number 1, the preamble. The preamble is the clause that identifies the type of agreement, the date of the agreement, and who the parties to the agreement are. When you're looking to acquire consent or release from a willing participant, you need information in the preamble to include a recitation of what each party is giving up in order to enter into this contract. That's called consideration. This is important because we want participants to contracts agreeing that this type of contractual relationship can be formed. Absent a proper recitation, absent a proper preamble, you might not have a valid agreement, giving the other party an opportunity to challenge that agreement at a later date. The second clause is the consent. The collaboration agreement should contain a consent clause, making it clear that the collaborators agree to be filmed and recorded. It's also a good idea to include a description of the project and what is expected by the collaborator within the project. Using a broad description may prevent a collaborator from later claiming that he or she was not prepared or aware of what he or she was getting into when they entered into the agreement with you. So basically, your goal here is to define the relationship between the two of you, what your expectations are of the other party, and what the other party's expectations are of you. Number 3 is the assignment. Every contract in this genre should have an assignment of rights. Legally, this clause gives the influencer the right to use the collaborator's image, his or her name, likeness, and any other rights needed to include the collaborator in the actual project. It also grants the influencer ownership rights over the collaborator's contribution. This can help in a few instances. First, it could prevent the collaborator from making claims later on that the influencer misappropriated or infringed on the collaborator's rights of publicity or privacy. That's very important. Second, it can also prevent the participant from claiming an ownership interest not only in the materials that were created, but in the profits that are realized as a result of the collaboration between the two parties. So this assignment should be broad. It should legally assign the collaborators rights in any project over to the influencer and make sure that it's very clear that the collaborator owns nothing as part of the collaboration. This includes things like intellectual property rights as well as any publicity rights, which also could include various uses, commercial uses, advertisements, and promotions. Clause number 4, the waiver. All right. This clause should be included in every collaboration agreement in order to prevent the collaborator from later suing the influencer for any claims arising from the collaboration between the two of them. It's a good idea to include a list of the possible claims that any collaborator could anticipate in filing against you. Clauses like rights of publicity infringement or misappropriation, copyright and trademark infringement, invasion of privacy, misappropriation of ideas or concepts, things like defamation, libel, slander, and fraud. Having the collaborator waive his or her rights to these types of actions against you could certainly prevent future litigation down the road. Item number 5, irrevocability. Irrevocability is this idea that the agreement between you and the collaborator is never going to be changed. This can prevent a collaborator in the future from coming forward and saying, hey, this agreement was terminated. But if you have an irrevocability clause within the agreement, and the agreement can only be terminated by mutual agreement of both the influencer and the collaborator, that collaboration agreement is going to last indefinitely. So an irrevocability clause prevents a collaborator from later claiming that the agreement between the two parties has been terminated. Clause number 6 is the jurisdiction clause. Every contract should have a clause which specifies the state law governing the agreement and any disputes concerning that agreement. In addition, it should also include a specific forum for bringing the claims in an event that a claim is actually brought against you, the influencer. As a general rule, the best place for jurisdiction would be the city or the state where the influencer lives or where the influencer practices his or her business. Alternatively, an influencer could consider selecting a state that has laws more favorable to him or her, especially when it comes to issues like privacy or other rights concerning intellectual property. For example, New York does not recognize a right of publicity or a common law right of publicity, which makes it very difficult for any collaborator to sue you in New York for those claims. However, take conversely a state like California that has very favorable laws to such privacy interests. Overall, it's important to keep these collaboration agreements short and sweet. If the agreements are simple to understand, collaborators will have a difficult time making the argument that even a layperson can't understand this agreement. So providing somebody with a long and lengthy and complicated document containing difficult and complicated language, a court ultimately could find that a layperson would not understand that contract and not understand and comprehend the information. As a result of that, an agreement like that could be invalidated. Hey, if this is your first time joining us, please subscribe to our channel. Press the little notification bell so you get alerted as to when we drop our new videos. So I hope you've had a good opportunity learning about 6 important clauses that you can utilize in your collaboration agreements. Good luck.